claim regardless of the
Right,
CC&Rs, and you've already ruled on that.
Right, I was going to say that would be a separate issue than the actual damages.
Exactly.
Okay.
But as far as
Well,
the actual damages and what could be derived from the damage to the wall, I don't think this, I don't read this motion in limine to address the issues we're trying, is what I'm trying to say.
Okay. Mr. Connolly?
Yeah, just briefly, both the court's minute entry granting our motion for partial summary judgment and the minute entry denying the motion for reconsideration were both clear that these are claims which are interposed and interrelated to each other, so we would like to avoid any of those arguments that somehow this isn't a contract-based claim or this isn't a tort-based claim, that liability applies to both causes of action that we've raised.
And Your Honor, I can tell you at trial, I won't make any of those arguments. Any attorney's fees distinction I'll make is obviously going to be post-ruling to the court.
Okay, sounds good. All right, to the extent I need to clarify anything, I'll just clarify that the issues at trial will be regarding proof of damages, and that will include both proving any direct and consequential damages and the value thereof. All right, plaintiff's number 2, this is regarding the evidence of the offer to pay for the wall. I know that we don't have a jury where it's necessarily going to go cause an issue with the jury, but to the extent I can give you a ruling on what I think here, let me hear from you first, Mr. Connolly.
Yes, Your Honor. My client has been asking, or might even say begging, the Palestinos, the defendants, for years, since 2022, to help collaborate and coordinate the repairs to the wall. They haven't been interested in doing that. Since the court issued its minute entry granting the motion for partial summary judgment in the last maybe 2 months, or not 45 days, they've now indicated a newfound desire to come in there and make the repairs. The only reason they want to make the repairs, as we've addressed in other motions to the court, the motion to amend, is because they want to sell their house, not because of anything the court ruled on or because of anything else, but simply because they want to sell their house. We want to avoid any settlement discussions that have arisen over the last 45 days where there has been an attempt to get into the backyard and make these repairs. It's been sort of 4 years in discussions with defendants. It's been 2 years since this litigation has been ongoing, and this seems to be a very, very last minute attempt to try to make the defendants look a little bit more responsive and reasonable. We don't want to get into an issue where counsel is asking, well, what about the last 45 days when we've been actively litigating for 2 years and actively requesting repairs for 2 more and have heard nothing from defendants?
So Mr. Cause, I know this, let's just limit the discussion to the current complaint. I know that there may be issues that this could be relevant to if I was to grant your motion to amend. But as to the liability or the damages issue that's currently before the court, I guess what's the other relevant purpose here for this evidence?
Well, we'll be submitting to the court in a brief law regarding offers by one contracting party, since the court's ruled this as a contract claim. Contracting party offering to fully perform and a refusal we believe, unreasonable to allow them to fully perform, thereby relieving them of their legal obligation to perform. And there's case law on that that goes back for decades. The other issue is typically these would not be, the premise is wrong here. They're arguing this is an offer of settlement and it's a proof of some kind to establish liability. If you look under the rule that prevents that 408, that prevents the admissibility of offers of settlement, it can come in for other issues, just not to establish liability. Well, liability is already established in this case. We conceded under a negligent tort theory full damage to the wall, and we're getting ready to give a stipulation to the court for the full cost of repair that plaintiff has disclosed in this case. So that's not even an issue in this matter. It has more to do with the contractual rights and obligations between the parties under Arizona law. And that's why we're offering it. And as far as 45 days, it's been a lot longer than that. My client had to get an estimate, two estimates actually, because the first estimate, plaintiffs then came back and said, yeah, but we want all of this other stuff done regarding waterproofing and sealing and et cetera. Since we don't want it to do it again, we went back, got another estimate, and then submitted that to the HOA, waited for their approval, got the HOA's approval, and then under the obligations of the CCRs and the HOA board's approval or architect committee approval, and their instructions, went back to Mr. Conley to get his client's permission to have access to the other side of the wall in order for us to fully replace it under the HOA approved submittal. That access was denied. So that was 2 months ago approximately, I believe, is when that was confirmed. And I think Mr. Conley, and I not in a nefarious way, but I think maybe he had to discuss it with his client and everything. I think the ball was in their court for about a month before that. So it hasn't been 45 days. It's been much longer than that, which is evidence that can be put on a trial. My client can testify to that. And I think it's clearly relevant to this case and the damages side of it. It's not offered to establish liability for damage to the wall, and it obviously plays a role. Plaintiffs are making a lost rental income claim. Well, if you fail to mitigate, and there's certain mitigation arguments and timeframes, that all comes in. They're making insurance claims that their insurance has cost them more. Well, if you don't let us fix the fence, how do you claim additional insurance increases? Assuming that evidence is going to be put on anyhow, I don't know. So it goes to a lot more issues than, in fact, it doesn't even go to the liability issue, which is the only preclusion under the rule.
Well, I mean, Rule 408 says that it's regarding disproving the validity or amount of a disputed claim. So I think it could go to damages, a specific, like, for example, if you made an offer of compromise saying, I offer you $50,000 to compromise to settle this case, then that offer couldn't then later be proven to show, well, the damages in this case are only $50,000 because that's the offer that was made. I think that that's something that falls right under Rule 408.
Well, we're stipulating to the cost of the wall, though, Your Honor. It takes it out of the equation.
Right. Which, again, you're stipulating to the cost of the wall. So I can see where, for example, if plaintiff is requesting lost income because somehow this wall has prevented them from renting out their house, and they're saying they've lost X amount up to the day of trial, and you want to present evidence that says we offered to fix the wall 6 months ago, so they shouldn't get that lost income for those 6 months. That may be, I think, another purpose under 408, because 408 says it can be as admitted for another relevant purpose. But I think outside of that, I don't think that I could consider it in terms of what the damages should have been. And then I guess I'm thinking that the only other real purpose would be if there's a later attorney's fees dispute. I don't think you have to present this evidence to me to consider under Warner, for example, whether the case could have been settled or something to that effect.
I don't think 408 applies to post-trial motions for fees and costs, but it might. I don't know. I'd have to look at it again. It's been several years. But I think for the purposes of trial and addressing the motion in limine, which number 2, which would apply to the trial itself, I think the court's analysis is correct. Plus, we're not putting on, I don't care what the amount of the cost at that time. We were going to pay. In other words, the offer to fix the fence did not come with a price tag. We had a, there wasn't a request for an agreed upon price tag. We asked for access to let us fix it at whatever cost that would be. So it really wasn't even a monetary offer.
Okay. Mr. Connolly.
Yeah, I'm looking at the email which Mr. Causey sent, which contained a notice of architectural approval from the CC and from the association regarding the wall, but there's no specifics in there regarding a cost, what the scope of repair is going to be. As a matter of fact, the only reference I see here is like-for-like replacement of back fence, which is a problem, as we will address with our experts at trial, because like-for-like is not going to carry the day. There needs to be a water retardant or mitigating layer that in the wall, which is not there right now. So that was another one of our concerns, that the proposal that we were receiving didn't provide any insight into a scope of repair, cost of repair, etc. We've set forth everything that we need to properly and appropriately repair this fence down to the penny, and we haven't gotten any specificity in that respect from the defendants. It's just a last-minute settlement proposal that the defendants hope they can rely upon when they walk into court after disregarding this dispute for 4 years and say that they attempted to be reasonable in the last 60 days.
All right. Well, it sounds like for this one, it really just will depend on what the evidence is that plaintiffs present. So I think on this one, I'll just have to defer ruling until I see what the evidence is that comes in from plaintiff's side first, and then whether or not there's a relevant other purpose for bringing up these negotiations. Because 408 does permit the relevant other purposes. So I'll have to make that decision once the evidence has been more fully fleshed out.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. All right. Any questions about the motion in limine rulings or anything else at this time from your perspective, Mr. Connolly?
Nothing from plaintiff, Your Honor. Thank you very much for your time.
Mr. Cause?
Nothing, Your Honor. Thank you.
Okay. Let me ask you, it seems like this is a pretty, there's not a lot of, I guess, legal issues going on in this case. It seems like your clients might be entrenched in their positions, but if this is something that my other case doesn't settle, and we have to find a new date for you, would it be beneficial to go to another judge for a settlement conference or something to that effect? Because it seems to me that this is something that maybe if they heard from another judicial officer on the various points, they could reach a resolution without having to spend the cost of going to trial. You know, I'm certainly happy to do the bench trial, either on the dates that are set or when we continue it. But you know, I wanted to throw that offer out to you since you've really whittled down the issues here. It's damages and then the cost of the wall's already been. It sounds like you two have reached an agreement on that. And so if there's any way that I or anyone else on the bench can assist with this matter, we're all happy to do so.
I would agree with Your Honor's analysis insofar as the liability was just established in the last few months, and then I don't think we learned that defendants will be stipulating to the cost of repair of the wall as we disclosed it until last week. That was a point of the majority of the contention in the case, other than liability. On the issue of damage, it was obviously the focus. And we learned last week that defendants will stipulate to that amount, which allowed us to think, well, maybe this is appropriate for a bench trial. And so, yes, Your Honor, the remaining amounts that are not stipulated to include such things as builder's fees, a slight increase in insurance, permitting fees, lost rents, but it's not, the damages are nothing approaching cataclysmically substantial. And so since the dust has sort of settled with regard to A, the issue of liability, and B, the stipulation of the largest component of damages, a settlement conference before a judge would be very helpful.
Mr. Cause?
Yeah. First of all, Your Honor, I'm sure counsel may have simply forgot the estimate that was submitted to the HOA and was approved was provided to counsel before it was ever submitted. There were negotiations that went on, and we were asked to get bids where the back of the wall was sealed properly and all this. That was done and submitted, and there were still some other issues that plaintiff wanted that we could not agree to. In addition to the cost of fixing the wall. The cost of fixing the wall has been, quite frankly, put to bed for months. It's been other issues, primarily the ones that are getting tried, and then there were a few others like removing a palm tree that had already been removed 6 months earlier, and some other issues. What the court's got to understand is plaintiff doesn't live on this property. It's rental. My understanding is he lives out of state. So I don't know if that's part of the disconnect. The problem, though, in settling this case is not with the damages that are going to be tried. At least my understanding. Because every time we've tried, and I won't go into specific numbers, offerings of monetary with the court, since it's a bench trial at this point, but my understanding has been the holdup is the attorney's fees. That the tail's wagging the dog and has been. And whether assistance or another conference with a judge pro tem or whatever would get us beyond that or not, I don't know. I know that it hasn't to this point. My understanding is the attorney's fees being requested exceed the damages now being at issue, is my understanding. But I could be wrong, and counsel might want to clarify that if we get to that point with the settlement judge, if we tried it again. But yeah, if the trial got bumped, I mean, I would still give it a try. I just don't know that under those circumstances it would be highly successful.
Okay. And remind me again, Mr. Cause, when did you say you were anticipating filing your reply on the motion to amend?
It's due the 3rd, but I'll try to get it filed by the end of this week, Your Honor. Which I think, what's that, 29th, 30th? Oh, 31st.
31st. Yeah.
Yeah. I guess it's due a week from today, but I'll try to get it in early. I've got my legal assistant is having health issues, and I found out today she'll be gone another 2 weeks. So it's
Okay.
tough for me to speed things up right now.
So let me propose this then. I have a trial starting tomorrow that goes through next Tuesday or Wednesday. And then I have the final trial management conference on the other case that's set to go at the same time as your case next Monday. So if you get that reply filed by the 31st or the 3rd, then I can probably give the motions a review. And then both I'll know, 1, whether the other trial is going to go, and then 2, what I'm going to do with that motion. So maybe we can I'll aim to have my staff reach out to you by the end of next week to let you know what the situation is with the other case, and also to get out a ruling on the motion to amend. And then maybe we can try to set another quick status conference to come back and talk about things.
Yes.
And either if we need to find a new date for the bench trial, and setting up a settlement conference with another judicial officer.
I will do everything I can, Your Honor, to file it. I'll file it as soon as I can. If that's
Okay.
in 2 days, I'll do it in 2 days. I'll get it as soon as I can.
Yeah, I mean, Friday or next Monday is fine. Like I said, I'm going to be in trial anyway for the rest of the week. And so,
Okay.
depending on how that trial goes, even if you filed it early, I may or may not be able to get a ruling out until next week anyway.
Okay. Thank you, Your Honor.
Mr. Connolly, does that plan sound okay with you?
Very satisfactory. Thank you, Your Honor.
Okay. All right. Well, is there anything else that the court can assist with or that we should discuss before we adjourn today from your client's perspective, Mr. Connolly?
Nothing from plaintiff. Thank you, Your Honor.
Mr. Causey?
No, Your Honor. Thank you.
Or Mr. Cause? I don't know why I said Causey. Sorry.
It actually is Causey.
It is Causey. When you
Yeah, there's a
announced, I
Y
thought
at
you
the
just
end.
said
Yes.
Cause.
Yes.
I made a note because when you announced it sounded to me like you said cause.
It probably
So I
cut
made a
off.
note not to say Causey because that's what I was going to say. So my apologies. Causey.
No, Your Honor. It's perfectly fine.
Okay. All right. Well, then thank you both for your appearances today. We'll be in touch with you about what happens with the other trial. Otherwise, I hope you have a good rest of your day. Thank you.
Thank you, Your Honor.